Good morning, good evening, good afternoon. Ehline tends to cause a lot of consternation to people in my Discord, or at least the people that watch him for reasons that I don't understand. Probably because he's retarded. He's about the dumbest motherfucker I ever saw. I mean, maybe he can practice personal injury well, but he says a lot of stupid shit. I don't think he understands a lot. I don't think he bothers to do any research on anything. He just likes to make slides, from what I've seen, that regurgitate the things that he was going to say anyway. So he writes a slide, he puts it up as proof that he's right, and then he says the thing that he was going to say in the slide. So he confirms that what he says is correct. Anyway, this video is posted to my Discord, and so I figured I would watch it with you, and we would be annoyed together.
You can't resist police today because of the 1900 holding of Bad Elk versus the United States. John Bad Elk, who was a Native American, being put through assimilation.
They don't teach
you don't know what assimilation is. If you don't know what
So Bad Elk did not take away your right to resist the police. And John Bad Elk was not resisting assimilation. And they don't teach Bad Elk versus the United States in law school because it hasn't been overturned, but the principles in it, as far as self-defense, your right to defend yourself against an unlawful arrest, have been eliminated in a lot of jurisdictions, in most jurisdictions, by statutes. So this is the Wikipedia page. If you want to get a good look at it, you can go through Wikipedia. Wikipedia for things like this is pretty good. This is the part that really deals mostly with the issue. But the big deal is that there is a difference between common law and statutory law. Statutory law trumps common law. If the legislative branch does not make a law that covers a situation, that situation has probably been dealt with by a court in the past, and courts can look at, in most instances, courts can look at how other courts have dealt with it in the past and use common law, which is essentially court-generated law. Now, if you remember, our federal government and all of the state governments have a three-branch system of government. You've got the judicial branch, which interprets the law. You've got the executive branch that enforces the law, and you have the legislative branch that drafts the law. They write the laws. And so you can see that if it's the legislative branch that's tasked with drafting the laws, any law that they draft will have to be enforced by the executive branch and interpreted by by the judicial branch. But the judicial branch can't write laws that overrule or usurp the legislative branch's role as the writer of laws. So statutory law trumps common law. If there's a statute in place, the court has to go by what the statute says, not by what a prior court had held before the statute. And Erie Railroad versus Tompkins held that there is no general federal common law. And they overturned Swift, I believe. Yes, they overturned Swift v. Tyson. So there's no federal general common law. Even before that, I mean, back almost at the foundation of our federal system, back in 1812, the United States Supreme Court found that federal courts cannot make common law crimes. They can't make common law crimes. They could do a few things: contumdency, and to enforce the observance of their orders. But they can't make a common law crime. So where does Bad Elk fit in? Well, let's go through the history of Bad Elk. So John Bad Elk was a policeman. He was a policeman in South Dakota on an Indian reservation. One day, John Bad Elk, for funsies, fired off his gun into the air at his home, or at his mom's home, I forget which, but he just shot his gun in the air. There was a police captain, Captain Gleason, who heard these shots and went to investigate. He found John Bad Elk there, and he asked John Bad Elk, "What's going on? What were you shooting at?" And John Bad Elk said, "I was just firing my gun in the air for fun." So the police captain went and talked to the policeman and asked what he was doing. "Just shooting my gun in the air for fun." They're in the middle of an Indian reservation in South Dakota. I mean, it's not like they were in the middle of a big city. There's no law against it. There's no federal law against it, and there's no state law against it. Just so you know. So Gleason says, "All right, we'll talk about this in the morning." Cool. Well, morning comes, and John Bad Elk doesn't go down to the police station. A couple days pass. Captain Gleason wants to talk to John Bad Elk, so he sends a couple Indian police officers, to go arrest John Bad Elk for doing something that isn't a crime. They go out to arrest him just on the oral order of Captain Gleason. There is no complaint. There is no warrant. So they go out there to arrest him, and they're like, "We're going to take you to the Pine Ridge Agency." And John Bad Elk says, "Yeah, that's cool, bro. We'll go in the morning. I've been out all day doing stuff. My horse is tired." I think before that he said he was going to go to his brother's and get a horse. They went to the brother's place. The horses were all out on the range, so there weren't any to saddle up and ride. So John Bad Elk stopped at his mom's house on the way back to get a rifle so that he could shoot prairie chicken. I don't know what a prairie chicken is, but I'm assuming it's some sort of a native bird like a grouse. And then they went back to mom's house, and I guess there are now like 4 or 5 of these police officers there to make the arrest, as police officers do. And so they go in, they follow John Bad Elk into the house. He's smoking for whatever reason. That seems to be important for the story. And, he's basically said, I'll go in the morning. I'm going to go in the morning. So they go out, and then there's like a couple of them went to go tell the captain. He said, "Yeah, that's fine. Just watch him. Make sure he doesn't like try to flee for a non-crime." Well, anyway, then 2 other cops decide that they're going to go and make the arrest. John Killsback is the cop who ended up getting shot. Now, the official narrative by the cops is that Bad Elk came out and was like, "What's going on?" And then for no reason whatsoever, he just shoots and kills John Killsback. John Bad Elk's story is he went out to be like, "Yo, what's going on?" I said I'd go in the morning, and John Killsback reached for his pistol, his revolver, and Bad Elk saw him, but already had a rifle in his hands, and so bada boom, bada bing, John Killsback got shot a couple times. All the other cops ran for cover, and John Killsback ended up dying from his wounds. Okay? So they get to court, and the defense wanted to have a charge read, basically to the jury. They wanted to say that from the evidence as it appears in this action, the policemen who sought to arrest the defendant in this action prior to the killing of the deceased were justified in the arresting of the defendant, and he had a right to use such force as a reasonably prudent person might do in resisting such arrest by them. The court denied that request and charged them that the deceased, John Killsback, had been ordered to arrest the defendant. Hence, he had a right to go and make the attempt to arrest the defendant. The defendant had no right to resist him. It is claimed on the part of the defendant that he had made no resistance and that he was willing to go with the officer in the morning. I charge you, of course, that the officer, John Killsback, had a right to determine for himself when this man should go to the agency with him. Essentially saying, this is saying that John Killsback had the right to use whatever force is necessary, up to and including lethal force, to bring John Bad Elk back to the agency. In this connection, I desire to say to you, gentlemen of the jury, that the deceased, being an officer of the law, had a right to be armed. That means John Killsback had a right to be armed. And for the purpose of arresting the defendant, he would have had the right to show his revolver. He would have had the right to use only so much force as was necessary to take his prisoner, and the fact that he was using no more force than was necessary to take his prisoner would not be sufficient justification for the defendant to shoot and kill him. The defendant would only be justified in killing the deceased when you should find that the circumstances show that the deceased had so far forgotten his duties as an officer and had gone beyond the force necessary to arrest the defendant and was about to kill him or inflict great bodily injury on him, which was not necessarily the purpose of making the arrest. And that was the charge. It was duly accepted. So, the United States Supreme Court said, like, bro, we got problems. You got problems. You can't make an arrest for a non-crime. You can't make an arrest, even if it is a misdemeanor. You can't make an arrest, at least not under federal law or South Dakota law. You can't make an arrest for a misdemeanor that's not committed within your presence, unless you have a warrant. You didn't have a warrant. So the arrest was unlawful. And then the court talks about it common law and says, at common law, if a party resisted arrest by an officer without warrant who had no right to arrest him, and if in the course of that resistance the officer was killed, the offense of the party resisting arrest would be reduced from what would have been murder if the officer had the right to arrest to manslaughter. What would be murder if the officer had the right to arrest might be reduced to manslaughter by the very fact that he had no such right. So an officer at common law was not authorized to make an arrest without a warrant for a mere misdemeanor not committed in his presence. If the officer had no right to arrest, the other party might resist the illegal attempt to arrest him, using no more force than was absolutely necessary to repel the assault constituting the attempt to arrest. So then it talks about, there's no statute giving them the right to arrest without a warrant on a charge of a misdemeanor not committed in their presence. They find no authority under the United States. They find no authority under the laws of South Dakota. There's no rule or regulation for which they found that prohibits the firing of a gun there for fun, nor do we find any law, rule, or regulation which authorizes an arrest without warrant of an Indian not charged even with the commission of a misdemeanor. So they kick all this stuff back. They kick all this stuff back to the circuit court to make a decision about how to charge John Bad Elk. They do say that under common law, he had no right to unnecessarily injure, much less kill his assailant, but where the officer was killed in the course of disorder which naturally accompanies an attempted arrest and has resisted, the law looks with very different eyes upon the transaction, so it would change from murder to manslaughter. And so John Bad Elk, might have gotten a lighter sentence because there was no right to arrest him. Still probably going to get popped for manslaughter, but what are you going to do, right? So what does this mean? First of all, there was no assimilation going on. John Bad Elk was not resisting assimilation. The police officers who came to arrest him, like John Killsback, he was an Indian police officer. John Killsback was an Indian police officer. The only Captain Gleason, I believe, was a non-Indian. And he says, cousin, you're a policeman. You know what the orders are. and there was Lone Bear. That was one of the policemen. High Eagle was the policeman who accompanied John Killsback. So these are all policemen. These are all policemen. I'm sorry, these are all Indians. So this isn't the federal government attempting to assimilate Indians. This is a bunch of Indians attempting to arrest somebody for a non-crime, attempting to arrest another Indian, an Indian policeman, for a non-crime without warrants. So it's not assimilation. And now, does John Bad Elk mean that you have no right to resist police? Well, no. Under common law, John Bad Elk points out that under common law, the kind of norm common law at the time, each state would have its own because they have their own courts, and so they would come up with different interpretations of the common law based on what their courts have determined to be the best course of action, if their courts even have common law. But the kind of general common law said that you could resist an unlawful arrest, and if you ended up killing the police officer who was attempting to arrest you unlawfully, instead of being charged with murder, you'd be charged with manslaughter. Now, most states have statutes now regarding arresting, resisting arrest when you can, when you can't. California, you can't resist an unlawful arrest. In Texas, you can resist excessive force. So each state is going to have its own statutes saying when and how you can or can't resist an unlawful arrest. A few states will still have common law. And for those states, you have to look to what their common law tradition is, because there's no universal common law. So you have to look at what their common law tradition is on whether or not you can or can't resist an unlawful arrest. But there are states where you can resist an unlawful arrest. Still, to this day, there are states that allow you to do that. Now, I don't recommend that you resist an unlawful arrest because cops, as we can see, if the cops do have probable cause to arrest you, and if they are arresting you for a crime that's like a misdemeanor committed in their presence, or if they do have probable cause of a felony, or just depending on how your state law is written, they may have the right to use force against you up to and including lethal force. And if you attempt to kill them by resisting an unlawful arrest or what you believe to be an unlawful arrest, no one ever knows what the policemen know. So it's almost impossible for you to determine at the time whether or not the police have probable cause to arrest you, etc. So you should never, in my opinion, resist an unlawful arrest or what you believe to be an unlawful arrest. You should allow it to be fought out in court where you're not going to die, where you're not going to get beat up, where you're not going to get injured, and then, oops, find out later that it wasn't an unlawful arrest. That's like the worst of all worlds. You think that you're resisting an unlawful arrest, and you end up getting hurt or worse, killed, and it turns out that a court finds the arrest wasn't an unlawful arrest. And that can happen. That does happen. And so I just really advise you, as a matter of practicality, let your lawyer fight it out. If you're unlawfully arrested, but you don't get hurt or killed, you still might get a payout. You still might get a really good payout. And nothing is worth sacrificing your health or your life over. Anyway, that's all I got for you. Ehline's an idiot, and Chili's an idiot. Thanks for watching. Have a great day.